So I'd like you to read Fordyce versus Seattle. That's case law.
Sir, I've already
Hang on, I'm telling you that right now under NRS 197-200.
I just you have a big plan and idea
No,
of
I
the
don't.
narrative in your mind.
I don't
You can
really.
let that play out. You refuse to identify yourself. You're required to give your name.
I refuse to identify myself. That's nobody ever asked me to.
Hey everyone, welcome back to U.S. Corrupt Cops, where we uncover the truth behind clashes between citizens and law enforcement. Today we're diving into a tense confrontation at a Nevada prison, where a First Amendment auditor's attempt to film in a restricted area sparked a heated encounter with authorities, raising big questions about free speech, trespassing, and the limits of public access. But before we get started, if you enjoy this video, drop a 1 in the comments, and if it's not your thing, let me know with a 2. I'd be so grateful if you'd leave a comment below before you head out. Now, let's jump into today's story. On August 30, 2022, Drew Rybar, a First Amendment auditor, attempted to record video at the Northern Nevada Correctional Center in Carson City, Nevada, a medium-security prison. He stated he was auditing the publicly accessible areas of the facility, intending to film in the guest parking lot and capture what was visible from outside. While filming on a road within the correctional center property leading to the facility, he was approached by Lieutenant Aaron Ryer from the Nevada Department of Corrections.
Hi there.
Hello, sir.
What's your name?
For you.
What's your name?
Lieutenant Ryer. What can we do for you?
I'm just taking pictures and filming.
Okay. Could you do it off the property, please?
Is this a public roadway?
No, this is not a public roadway.
Where does it say
This
there's...
belongs to the prison, sir. I need you to film off our property.
Where does it say no trespassing?
Sir, I'm asking you to please film off the property. Otherwise, I'll have Carson SO come tell you to get off the property.
Well, can you show me where it says no trespassing?
No, sir, I'm not showing you anything. I'm telling you, you need to leave the property.
Well, then if
I'm
there's
a
no...
sworn peace officer for the state of Nevada, sir.
I appreciate that.
It's not an unlawful order, so could I please get you to go off the property?
If it's not an unlawful... It's not an unlawful...
Sir, yes or no, so I can call Carson SO.
Well, let me ask them questions. You're saying I don't get to ask questions?
I will call Carson SO and let them know.
Okay.
Thank you.
Tell them that I'm exercising my constitutional rights. Okay, here we go. So we've already been stopped. And we're gonna go look for a no trespassing sign. We're gonna wait to go across the street here. Okay. No trespassing signs anywhere that I can visibly see here.
Drew Rybar searched for a no trespassing sign, but could not find any on the property. According to the Nevada trespassing statute found in Section 207.200 of the Nevada Revised Statutes, any person who intentionally enters or stays on any land or in any building after being warned within the prior 24 months by the owner or occupant not to trespass commits a misdemeanor. The statute applies to both private and public property. Although posting no trespassing signs is one way to provide a warning against trespassing, the law also allows an oral or written demand by the property owner or occupant to any guest to leave the premises. Therefore, no trespassing signs are not required for a trespassing conviction under the statute. It is possible that Drew Rybar could face a trespassing charge for refusing to leave the correctional center property after being asked to do so. Additionally, the fact that the property is government-owned does not automatically mean it must be open to the public for free speech or other activities. Access to the correctional center property is highly restricted. The Nevada Department of Corrections Visitation Manual, publicly available on their website, states that inmates cannot receive visitors without applying for visitation privileges. Individuals wishing to visit an inmate must submit an application to the facility where the inmate is housed for processing. A background check is conducted on the potential visitor, and if approved, the individual may visit during designated hours. The policy also specifies that visits from outside groups or media must comply with Administrative Regulation 120 concerning news media contacts and press releases. Under this regulation, news media visits require prior approval and must be arranged with the appropriate administrator with specific permission needed to bring cameras or recording devices. The regulation also permits approved visits by other media representatives, such as those producing documentaries, nonfiction books, or freelance projects. Drew Rybar would likely be considered this type of visitor. To film at the facility in compliance with the regulation, he would need to submit a written request at least 2 weeks before starting the project.
And we'll just kind of keep going over here now. These guys are surrounding my truck. They're preventing my path of movement down a public road.
Yes, sir.
And what was your name again?
Lieutenant Ryer, I already told you, sir.
And do you have a badge number? Closing the window.
Yes, sir.
And what's your badge number?
10,300.
10,300, okay. So just to let you know what I'm involved in.
Sir, I'm not worried about what you're involved in. You're on our property. I need you to leave. I have nothing else to say. Carson is all rise. Thank you.
Again, where are the, okay. Okay, so I'm gonna say it real loud with your rolled up window. So I'd like you to read Fordyce versus Seattle. That's case law.
Sir, I've already.
Hang on, I'm telling you that right now under NRS 197-200, you're oppressing my rights under the color of law. So your qualified immunity may not exist. I'm exercising my constitutional right to film in public. The most recent court, the 10th Circuit in July 22nd, in Izari versus Yahia. So that's your case law for what I'm doing. You have a nice day.
Drew Rybar referenced case law supporting the First Amendment right to film to justify his actions. In the 1995 case of Fordyce versus Seattle, the Ninth Circuit Court of Appeals, which has jurisdiction over Nevada, recognized a First Amendment right to film matters of public interest. He also cited the 2022 case of Irizarry versus Yahia, where the 10th Circuit Court of Appeals concluded that based on First Amendment principles, there is a right to film police performing their duties in public. Although 10th Circuit precedent does not legally bind Nevada, the Ninth Circuit acknowledged a similar right in the 2018 case of Askins versus U.S. Department of Homeland Security, stating that the right to film matters of public interest includes recording law enforcement officers performing official duties in public places. However, this right does not grant unrestricted filming on government-owned property. The court clarified that whether a location is considered public depends on its nature. In a traditional public forum, such as a street, sidewalk, or park, the government's ability to restrict speech is limited, with content-based restrictions allowed only if they are the least restrictive means to achieve a compelling government interest, and reasonable content-neutral restrictions permitted if narrowly tailored to serve a significant government interest while leaving ample alternative communication channels. In contrast, restrictions in a non-public forum need only be reasonable and viewpoint neutral. In the 2003 case of ACLU of Nevada versus City of Las Vegas, the Ninth Circuit outlined 3 factors to determine if a location is a public forum: the actual use and purpose of the property, especially as a public thoroughfare and its accessibility, the physical characteristics, including its location and boundaries, and the traditional or historical use of the property and similar properties. Although Drew Rybar filmed on a road, it was not a public thoroughfare but used only by those with business at the prison. Despite no physical boundaries restricting access, regulations required visitors to obtain facility approval, and a large sign indicated entry onto correctional center grounds. These factors suggest the road is a non-public forum, supported by Supreme Court precedent. In the 1966 case of Adderley versus Florida, the Supreme Court ruled that a jail is not a public space, and protesters who refused to leave could be convicted under the state trespassing statute despite engaging in First Amendment activity. The court noted that the demonstrators entered jail grounds through a driveway used solely for jail purposes without permission. Similarly, in the 1974 case of Pell versus Precunier, the Supreme Court held that the First Amendment does not grant the press special access to information unavailable to the public, and that journalists have no greater right to access prisons or inmates than the general public. Based on this precedent, A court would likely find that the filming restrictions at the correctional center did not violate the First Amendment, and Drew Rybar could be arrested for trespassing if he refused to leave after being asked.
Okay, and that one says, no parking, no use of tobacco. Well, we can see my feet how close I am to the road here. So I should be on the public easement. That was pretty fast response just for looking at their sign on the road. I am good. How are you?
Sergeant Smith, I'm the shift sergeant.
What's your name and your badge number?
I'm Sergeant Smith.
Sergeant Smith?
Yes, sir.
And your number?
I don't have a badge number. I have an employee ID number, 38095. Can I ask what you're doing out here?
I'm exercising my constitutional right to film in public and to disseminate the information as a member of the press.
Okay, I can only let you go so far, sir. You can't come on the state's property. We're not allowing you on there. You're also not wearing the right colors for that. If you wear a blue shirt, we can mistake you for an inmate.
Well, let me ask a question here. The state owns this road?
I believe they do, yes.
Okay, are there any no trespassing signs from?
I don't know, did you see any on your way in, sir?
I documented everything and there are no trespassing signs that I can find. Is this a publicly funded road, open to the public? And if I'm a visitor, can I come down this road and park?
Are you here to visit an inmate?
I'm here to do my business.
Okay. Well, I will let you know, sir, that we have called the sheriff's department.
Okay.
And they will be on their way. Okay.
Okay. So, do you want to interfere with me accessing a public roadway?
You can access a public roadway if you believe this is a public roadway, by all means. I'm refusing to let you on the state's property.
Oh, I don't want on the state's property. Anywhere that the public can go here, I should be able to go, right?
100%.
But other than that, I'd like to continue down the public roadway to any public parking to where visitors may park and see what they go through to come and see their friends and family that may be incarcerated inside. Is that illegal? You're standing in my way, impeding my path.
There's many ways you can walk.
Well, I'm trying to purposely stay close to the roadway. So if I keep walking, are you going to interfere with me?
I'm not going to interfere with you.
Okay, thank you. There's the warden's car.
Excuse me, sir.
Yes, sir.
How may I help you?
I'm just taking pictures.
No, sir, you cannot do this. I'm the warden of this complex.
Oh, good. What's your name, sir? Hang on. Let me get closer so I can hear you, sir. Let me get closer so I can hear you. Can I get closer so I can hear you? Can I get closer so I can hear you?
No, sir.
Oh, I can't get closer so I can hear you.
I'm going to ask you to remove yourself from the property.
Okay. Is this
Trespassing on state property.
Is this?
You are in an unauthorized position, property, sir.
Okay.
I need you to remove yourself from the premises, sir.
And what's your name, sir?
Sir, I need you to remove yourself from the premises.
What's your name, sir?
We call the little luck boy.
Yeah, he's right here. And sir,
This gentleman is trespassing on the property.
Sir, can you identify yourself?
I'm the warden of the complex.
And what's your name?
So I'm asking him to be removed as a trespasser.
Sir, what is your name? You've engaged with me, sir. What is your name?
He came onto the property without permission.
Sir, what is your name?
Is the facilities on lockdown?
Yes, it is.
This is disrupting operations.
This is disrupting operations.
Sir, what is your name?
Okay. Put that down. Put your hands behind your back.
Okay.
He is creating a disturbance on the property.
I'm not going to risk these guys at all.
The warden stated that Drew Rybar was trespassing on the property without permission and that his presence caused a facility lockdown, disrupting operations. In response, Carson City Sheriff Deputy Jason Bueno placed Drew Rybar in handcuffs.
Can I advise you one thing?
No, you may not. Right now, you have the right to remain silent. Anything you say can maybe use against you in a court.
NRS
You have
197-200.
Excuse me, I didn't interrupt you, did I?
NRS
Okay, if you don't want to hear your rights, then we're not going to talk about it. Okay, I'm not going to ask you any questions. Step over to my vehicle.
Okay. So I'm detained. Thank you, sir.
You're in custody at this point.
And what am I being arrested for?
You're being arrested for trespassing.
Okay, so where was the no trespassing signs?
I'll explain everything to you, but right now you're not under Miranda, so I'm not going to ask you any questions.
I'm just asking you questions.
Well, you don't have a right to ask me questions at this point. You have a right to get in the car.
What's the best way to do this?
Hop on in there.
So whatever we need.
We need some statements,
I'll be happy to.
so that way we have someone from the state here, that's going to press.
Yeah, no problem.
And then we're going to have to probably tow his truck too.
Yeah, I'm sure he's probably one of those advocacy groups.
I'm sure he is, and I don't really care about his agenda. I just care about that obviously he's disrupting the flow of business here. So if anybody had contact with him that gave him that trespass verbally, and he refused. I'll need that kind of in your guys' statements. We're going to do statements to the effect of the trespassing. This is it's a prison, it's a controlled area. All visitors are required to check in. He didn't do any of that. He refused to leave. They're on lockdown.
Do you want to do obstructing? I mean, they're cops.
Yeah. Did anybody ask him ID at all on the property?
Not to my knowledge, because I just asked him what was his name. He refused to acknowledge me. And,
Okay.
To give me why was he, what was his name, the purpose of it.
Okay. So we can do failure to identify too.
Yeah.
And then did you guys ask him for his name at all?
I did not ask him for his name. I just tried to see why he was here and tried to direct him off the property to building 17 over there, right down the road, to get some information.
Okay. So those three?
Yeah.
Deputy Bueno announced that he would charge Drew Rybar with trespassing, obstructing, and failure to identify. Under Section 197.190 of the Nevada Revised Statutes, which defines obstructing a public officer, any person who, after proper notice, refuses or neglects to provide required information or willfully hinders, delays, or obstructs a public officer in their duties commits a misdemeanor. In the 2019 case of Stubbs versus Las Vegas Metropolitan Police Department, the Ninth Circuit found that an officer had sufficient basis to arrest someone for violating this statute by repeatedly refusing to follow orders to step away from a traffic stop. A court might similarly find that Drew Rybar's refusal to leave the correctional center property provided probable cause for an obstruction charge. Regarding the failure to identify charge, Section 171.123 of the Nevada Revised Statutes allows a peace officer to detain anyone under circumstances reasonably indicating they have committed, are committing, or are about to commit a crime or civil infraction, and requires the detained person to identify themselves, though they cannot be forced to answer other questions. Although the Ninth Circuit previously ruled that arresting someone for refusing to identify violates the Fourth Amendment, the Supreme Court in the 2004 case of Heibel versus 6th Judicial District Court of Nevada upheld the constitutionality of this statute, stating that requiring a suspect to provide their name during a valid Terry stop aligns with Fourth Amendment protections against unreasonable searches and seizures. Thus, individuals in Nevada may face obstruction charges for refusing to identify themselves if detained on reasonable suspicion of illegal activity. However, Drew Rybar did not appear to refuse to identify himself, despite the warden's claims, making it unlikely he could be convicted of obstruction for failure to identify.
Thanks, man. Appreciate you, brother.
Any questions? Sir, you have my card. Just let me know. All right, thank you. Okay, so you do have the right to remain silent. Anything you say can and may be used against you in a court of law. You have a right to talk to an attorney and have an attorney present with you if you wish. You can choose at any time not to make any statements or answer any questions. Do you understand those rights? I'm bringing one in, just so you know. All right, sir, step on out, please. Face the car right here.
Left, correct.
Make a left. Have a seat in that blue chair. Got a little sweaty back there.
A little bit.
Did the air run in?
No.
I
think you're trying to hotbox me.
I had the air back there going.
Well, you rolled up the window that left a breeze.
What's that?
Yeah, you rolled up the window that left a breeze. So like I said,
Yeah,
I think
do
you
that
were
with
just
the
trying to
air
hotbox me.
conditioning,
You really do need to go read the 10th Circuit Court July
No,
22nd
I'm not
opinion.
going into any court today. I'm looking you
Bizarre
up for
versus
misdemeanor
yeah.
charges.
No,
And you
I
can do-
understand. But you arrested me for filming in public.
No, I did not. Trespassing and obstructing.
How did I obstruct?
Hey, I'm not going to get into it. I'm
I
sure
just-
that you have a big plan and idea
No,
of the
I
narrative
don't-
in your mind.
I
You
don't
can let
really.
that play out. You refuse to identify yourself. You're required to give your name.
I refused to identify myself. That's
Okay.
nobody ever asked me to identify.
Okay, well,
When I asked the warden
listen,
to
I'm
identify,
going to just tell you something. I'm
My-
not going to argue with you.
I'm not trying to argue. I'm trying
You
to
can do
get
this
answers
in
to
court
questions.
later on. I don't care what you have to say right
I'm
now
trying
about
to get
that.
answers to questions.
Drew Rybar stated that the criminal case against him was dismissed on December 20 as part of a plea bargain requiring a no-contest plea in exchange for a later dismissal. Court records are not publicly available, so the status of any charges could not be confirmed. On January 29, 2024, Drew Rybar filed a pro se lawsuit in state court, later moved to federal court, alleging multiple constitutional and state law violations including reckless driving, false imprisonment, unlawful vehicle seizure, grand larceny, and malicious prosecution. As of the date of this report, the case remains pending. Thank you so much for sticking with us until the very end. You're one of the few who go the distance. If you found this video insightful or thought-provoking, please hit that like button, and if you can, share it with your friends to spread the word. I'd love to hear your take on today's story, so drop your thoughts in the comments below. See you all tomorrow for more.